Coming up, a victory for a medicinal marijuana crusader at the Supreme Court of Canada. The High Court has overturned his conviction on charges of possession of pot for the purpose of trafficking and granted the Calgary man a new trial. Is this the thin edge of the legal wedge, which could see pot decriminalized and perhaps legalized here in Canada? That's next on CH's version of Reefer Madness meets Puff, the Magic Dragon. Canadians who use marijuana for medicinal purposes, and even those who light up for pleasure, only are likely sparking a joint in celebration today. The Supreme Court of Canada has overturned the conviction of medicinal marijuana crusader on charges of possession of pot for the purposes of trafficking. In a 7-0 judgment, the court granted a new trial to Grant Krieger of Calgary, who says he should have the right to distribute marijuana to people who need it to ease the pain of serious illness. Krieger himself suffers from multiple sclerosis and has legal permission to smoke pot for medical purposes. He doesn't have permission from the feds to supply it to others, but freely admits that he's done so anyway. Is today's Supreme Court ruling the thin edge of the legal wedge, which could see ganja decriminalized or even legalized in Canada? With us in studio is Hamilton trial lawyer Jeffrey Reed, and next to him, Alison Myrden, a medicinal marijuana advocate. Alison, do you see this ruling as a legal building block for the day when people can use the substance as they see fit?
I do, Mark. I think it's a huge step toward the right move. I think we've started to do something today that's making the voices of Canadians finally heard and making people who suffer from debilitating illness, giving them some place to turn.
Let's talk about your condition, Alison. You suffer from multiple sclerosis?
I do. I also have a debilitating and horrible pain in my face called tic douloureux 24 hours a day. That most of my medications, my 32 pills a day and 2,000 milligrams of morphine take care of.
Right.
So.
How much marijuana do you need to smoke to in order to get rid of this excruciating pain?
I'm one of the largest prescriptions in the country, Mark. I smoke anywhere from 15 to 20 marijuana cigarettes a day, literally around the clock. So otherwise I'm throwing up all the pills that I take and suffering from the many symptoms that multiple sclerosis has to gives to people like myself.
Right. Now, the government supplies you with marijuana? Is it?
No, absolutely not, Mark. I get my marijuana from compassion centers and from the street.
Alison, when you smoke a marijuana stick or cigarette, do you get high? I mean, is it the same as marijuana that is sold on the street? I'm talking about the medicinal marijuana.
Yes.
Is it the same as the marijuana on the street?
People often have their own opinion on that, Donna, but I know that when I smoke medical marijuana or marijuana, period, that I don't get high from it. I found out over 10 years ago when I approached my doctors about this same issue as to why I wasn't getting the same feeling I did when I was younger and I tried it recreationally. I wondered why that was, and the doctor said it was because there was so much for the marijuana to do as a medicine that there was nothing left for residual to get high from.
Interesting.
So,
but is it the same? Is it? You mentioned that you don't get it supplied by the government. So
No.
Is it the same as the government marijuana? The same as the marijuana that we're seeing sold on the street?
It's actually a little less potent than what we find on the streets, Donna, so that's a very good point again. But I do find with the marijuana I get on the street, I don't personally get high from it. I know people get different things, and the high, quote unquote, might be part of what they're looking for to help combat their illness. So I think that's a very important thing that we have to remember, is that all the associated effects of marijuana are imperative to medicinal use.
Okay, let's bring Jeff Reed in now. Jeff, the Supreme Court ruling really involves the judge's instructions to the jury. He ordered them to convict Krieger because what he did was illegal. Now, if jurors from here on in don't have to convict no matter what the law says, then isn't the law itself no longer enforceable?
Well, that's the old process of jury nullification that our courts told us about 25 years ago in the Morgenthaler series of cases is not permitted. At least you can't go to a jury and tell them that they can ignore the law. But the way I see this decision, and I have to read it more carefully, but I've just seen a summary, it sounds as if the court is saying you can't tell the jury to ignore the law, but if they need to follow their conscience, even if it is in conflict with the law, you can't take that away from them either, because if you do that, you're usurping the the right of the jury to make the decision, which is a constitutional right. And it goes back to a very, very old concept that the juries will, in fact, be allowed to follow their consciences. And for a long time, in ancient times, when we had such very, very harsh laws against relatively minor offenses, that was one of the real safeguards to liberty, that the law might have said, look, the person's guilty and they have to be hanged for it. Juries would just ignore it, and that was really effectively jury nullification. So it might well be alive, you just can't tell them that.
What happens then to the law, as Mark said? Does it mean that it will be thrown out? Does it mean if this continually happens and juries struggle and can't follow a judge's orders or directions, will the law become null and void?
That's partly a legal question and partly a political question. From the legal perspective, I think this is a very narrow decision. It simply says that when there's a medical exemption in effect, that the jury has to make a decision about really how far it goes. After all, as I understand the issue in this case, this fellow was not being charged with an offense because he had used it for his own purposes, because he had a medical exemption. It was because he was accused of trafficking it or having it for the purpose of trafficking to others. But you raise a very interesting question. What happens if another jury does it? Narrowly put, this is just one jury in one case doing it one time. But what happens if others do it? Yes, if it keeps happening all the time, it will probably force the legislators, parliamentarians, the government to go back and say, we can't ever get a conviction, so now what to do? So it may be that it will remain to be seen. We'll see how other juries do these things.
Alison, where do you get your marijuana from?
I buy a lot from the compassion centers, Mark. I get it from the street, and I get
Now, when
it
you
from
say, sorry, I don't want to interrupt. When you say compassion centers, you're talking about individuals who are giving you or selling you marijuana, in essence, trafficking it.
Yes.
Okay. Have these people been up on charges before?
Actually, some of them have been, but they've
And what was the result?
I don't believe there was a result. I believe it was left null and void for the time to see what happens in the courts in the few years to come. So, but again, I'm not exactly up on things. You'd have to ask one of the lawyers that question.
So now we can go back to Jeff and ask this. If this is the case, and it's happened more than once, Jeff, whereby juries, judges, the court of public opinion has said, you know what, on a moral ground, let's let this go. They're not hurting anybody, and they're actually helping other people, reduce the pain and the suffering that they're going through.
I think that each case will be approached individually, but the thing is, if there's a case where somebody is accused of transferring, it doesn't matter, selling, giving, effectively trafficking or having for the purpose of trafficking to give to somebody else, the case is going to depend a lot on the facts. If a person is just doing it for a sheer out-and-out commercial venture to somebody for recreational use, there's not going to be much sympathy.
Of course.
But take the kind of case which seems to be here in the Krieger case, where he says that he's been providing it, as I understand it, to others who he perceived to have a medical need. Now we appeal to the equities. Now we appeal to John Q. Public, who says, you know what, if somebody is really in pain and they really need this, then it doesn't seem right to convict. And in that class of cases, then it may well be that the convictions will become much more difficult to obtain, and it may eventually mean that the police will not see fit to prosecute so frequently or lay charges, because the prospect will be that they'll have difficulty getting a conviction.
Well, certainly something to watch for, and it could be a very interesting legal step in the process. Thanks so much to our guests today, Jeff Reed and Alison Myrden. We appreciate your time.
Thank
Mark.
you so much,
Donna.
Mark. Thanks, Donna.